Okay, moving on here in the chapter on civil liberties. We're in the PowerPoint, slide number 28, talking about the free exercise clause. Okay, remember there's two prongs or two aspects of the religious liberty provision in the First Amendment. One is the Establishment Clause, and then the second is free exercise. Okay, in other words, the freedom to exercise your religious beliefs in the way you so desire. Okay. Has that been curtailed within this pandemic? Yes, in that the gatherings at churches have been prevented, okay? That is technically a violation of our free exercise rights, as far as within that clause, the free exercise clause rights, okay? But again, within the pandemic, because you've got a neutral law of general applicability, it is constitutional, okay? I consulted an attorney, a federal attorney, about some of this, and what he said was this. I thought you'd find this interesting. Referred to church as being kept from gathering, or large gatherings at think some kind of sports competition or something like that. He said, listen, when a government initially does this because of a situation like this pandemic, the burden of proof is going to be upon the individual to prove what the state's doing is unconstitutional. But the longer states, continue these stay-at-home orders, and you can't gather at a restaurant, you can't gather in sports, you can't gather at school, you can't whatever, okay? The burden of proof is going to shift to the government to try to prove, why are you extending these stay-at-home orders for 5 months, 6 months, or whatever, right? Okay, so just realize that. Is that there's a reason for that in this case. But when it goes for a long time, it's harder for the government to prove that it's constitutional, okay? So getting back to the free exercise clause for religion, the idea that you can freely express your religious beliefs, okay? Going to church is one, okay? What the court has decided is that, it will protect your freedom of conscience, but where the state will begin to come in to perhaps regulate or limit religious expression is when outward behaviors affect others. Okay, there was a famous case in the 1800s where the court struck down polygamy in Utah, okay, from Mormons. Okay, this idea that, listen, a man with multiple wives or multiple women, that is not a positive social good. And so even though that's your freely held religious belief, we believe that that is a hindrance to the public good of America. So that free exercise has been prohibited, okay? Another example is a case called Employment Division versus Smith, where the individual basically worked for the Oregon Health Department, smoked peyote, okay, which is the drug. This individual was a Native American, and because of his religious beliefs, you should be able to smoke peyote. He smoked peyote on the job. Do you see the controversy here? Worked at the health department, but smokes peyote on the job. But again, his argument, and went to the Supreme Court, and at issue is Oregon's law prohibiting him from his free exercise of religion, in this case, smoking peyote on the job, is that a violation of his free exercise clause rights? And the court decided that basically it upheld Oregon's refusal to grant unemployment benefits for this guy that was fired, okay? Even though the smoking of peyote was a ritual in his religion. Again, the thinking is there are some limits of outward behavior that the state can regulate. Another interesting case, Edwards versus Aguilar. The court overturned a Louisiana law required creationism to be taught, okay, alongside evolution. And the court said that that is an unconstitutional exercise of religion and the argument was that creationism is non-scientific, okay? Again, this is interesting too, because in 2020, there are arguments against evolution not based on pure creationism, but on something called intelligent design. And to date, I don't think that's been challenged in court. But anyway, so anyway, that's the free exercise clause. Let's move on here. If you go to slide number 29, you're welcome to watch that YouTube clip if it's still up. But it's The Supreme Court nominee Neil Gorsuch, before he was nominated, discusses the Hobby Lobby decision. Okay, what was the Hobby Lobby decision? Under Obamacare, basically it mandated that all companies must supply abortifacients to its employees. Okay, abortifacients is a pill that you take that basically kills a baby. Okay, it's like an abortion pill. Okay, Hobby Lobby is a Christian organization, had a conscientious objection to that on religious liberty grounds, and so Gorsuch was asked about it. The court struck down that provision of Obamacare that mandated that corporations provide abortifacients to their employees if they had religiously held opposition to it. So anyway, you can check that out there. Okay. One of the things you got to realize when we're talking about the Bill of Rights and protection of religious liberty and all the others is with the creation of the Bill of Rights, okay, when something is decided by the basis of, it's the Bill of Rights, it is outside the control of Congress, okay? Congress can't strike down one of the Bill of Rights unless you create an amendment, okay? So they're basically pretty solid. They're on solid grounds there, okay? And here's a quote from Justice Robert Jackson in the case West Virginia State Board of Education versus Barnett that kind of gives you an idea of the strength of the Bill of Rights, okay? If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith thereon. Again, he's talking about that. Listen, in our Constitution, government can't force you to think the way you should think, okay? If you really wanted to apply that, you could say, well, government can't engage in political correctness either, right? Because that's forcing you to think a certain way. Kind of interesting. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities and officials, and to establish them as legal principles to be applied by the courts. One's right to life, liberty, property, free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. Okay, again, these are inalienable rights. These are pre-political. Government didn't give them to you. Government can't take them away, okay, is what he's trying to argue there. So perhaps that'll help you appreciate the Bill of Rights and their strength, okay? Okay, let's move on here. Slide number 31, freedom of expression, okay, freedom of speech. So the First Amendment provides freedom for expression, the right of individual, Americans to hold and communicate thoughts of their choosing, okay? Freedom of speech or freedom of expression is a fundamental right because it's an expression of human dignity, okay? Self-government. It's free speech is essential to the free market of ideas, okay? In societies that are not free, government will suppress your speech. You cannot write a blog condemning the government, okay? You cannot post something that is critical of the government, okay? But in America, the idea that you can, or all kinds of ideas, okay? This idea that the thinking was, let truth get out there. And that which is a false idea, it won't survive. That which is true, okay? Let it compete in the marketplace of ideas. And that which is true will continue to remain, okay? That's the argument of freedom of expression, okay? Freedom of expression is not absolute. If you go to slide 32, you do not have the right to yell fire in a crowded building for no reason. Why? Because people are going to die, right? You're going to create some sort of a stampede and innocent people are going to be killed. In other words, I can do whatever I want. I can say whatever I want. I'm an American. No, it's not unlimited, right? You've got to be careful that what you say doesn't incite a riot, perhaps. What you say doesn't lead to the death of a person, okay? In other words, if it can be tied back to you, you can be in big trouble, okay? And so, the First Amendment provides freedom of expression by prohibiting laws that unreasonably abridge our freedom of conscience, speech, press, assembly, and so forth, okay? So, slide 33, okay? So the first period of dealing with freedom of speech and whether we can or we can't, okay? The Sedition Act was passed in 1798 by John Adams. He was president, okay? We were in a quasi-war with France, and so John Adams passed, this bill was passed, this act was passed by Congress with John Adams' approval, which prohibited you speaking against the government, because they're thinking if you're in a quasi-war with France, you don't want to mess with people's morale. You want people to be patriotic and support the government as it's engaged in a war, okay? The problem is that it was also used to suppress those that were the political opponents of John Adams. Because to speak against the government, even if you're opposed to John Adams, was like, well, you're speaking against, you're basically weakening American morale in a quasi-war. So they basically suppressed a lot of people and prevented people from speaking or printing different things, okay? And so they made it a crime to print harshly critical newspaper stories about the president, okay? Fast forward to basically it should be 1919. I'm actually changing the PowerPoint here, okay? World War I rather. There was a case called Schenck versus United States, okay? And what happened was during World War I, this guy named Schenck mailed all kinds of little circulars to draftees, basically trying to discourage them to be in the war. Said the draft was wrong, okay? It was motivated by capitalism, this capitalist system. So they said, do not submit to intimidation, and basically, was trying to basically prevent the drafting of soldiers for the war, okay? So this was his speech. So the issue in the case were Schenck's actions, okay? The expression of this circular, is it protected by the free speech? Can you do that? Can you freely tell people that are being drafted you shouldn't be and speak out against that? Okay, what the court held was this. Schenck is not protected in this situation, okay? The character of every act depends on the circumstances. The question in every case is whether words are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. During wartime, utterances tolerable in peacetime can be punished, okay? So they established something called the clear and present danger test of speech. If what you speak presents a clear and present danger, your speech can be limited, okay? It's considered unconstitutional. Again, remember, free speech is not absolute. So as we fast forward to 1969, you got 50 years ahead, okay? You've got a case called Brandenburg versus Ohio, okay? Brandenburg was a leader of the Ku Klux Klan. He made a speech at a Klan rally and was later convicted under an Ohio law that made it illegal to advocate crime, sabotage, violence, or unlawful methods of terrorism as a means of establishing reform. You can't speak of terrorism to initiate reform. Okay? And so you also cannot assemble with any society group of persons to teach the doctrine of criminal syndicalism. Okay? You can't just gather with people to basically foster some form of criminality. So the court ruled that the Ohio law violated Brandenburg's speech, freedom of speech, okay? So they employed a different law, okay? Again, remember, the court has become more permissive in the modern era than in the earlier era. They are allowing more that they didn't before, okay? So they came up with this test called the imminent lawless action test, okay? Speech must be directed at inciting or producing imminent lawless action. Speech must be likely produce such action. If you cannot produce, in other words, let's say the guy gave a speech and a riot ensued, okay? If you can trace what the guy said, in other words, you ask the people in rioting, why'd you do it? Well, because Brandon gave this speech and, okay, well then Brandenburg is toast. However, if you can take a rioter and they're not connected to his speech, okay, Brandenburg's not on the hook because he passed the imminent lawless action test. If a lawyer can prove that this riot was not directly linked to this guy's speech, Brandenburg in this case basically is able to enjoy protection and his speech enjoys protection, okay? I'm gonna stop right there.